Welcome to the Office of Judges of Compensation Claims program on effective mediation. We're coming to you by Zoom today with the aid of YouTube and other technologies. Thank you for joining us. The subject today is how to best prepare for and get through mediation to have it be an effective process for you. And we're going to start with brief introductions. My name is Dave Langham. I'm the Deputy Chief Judge of Compensation Claims. I've been here since 2006. And we'll turn next to Ms. Carrier down in Sarasota. Ms. Carrier?
I'm currently the state mediator in the Sarasota district. I've been here since May of 2018. I've been practicing in workers' comp since 2002. I've had the privilege of representing both injured workers and the employer carriers throughout my career. And I enjoy mediation and the process, and I look forward to the presentation.
Excellent. And next over on my screen to my left, Judge Almeida.
Good afternoon. I'm Judge Edward Almeida in the Miami District. I have been doing workers' comp since I was an adjuster, and that's over 50 years ago. Since then, I've done claimant, carriers, been a mediator, and now a judge of compensation claims.
Very good. And last but not least, and in our order is our newest judge up in Panama City, Judge John Mooneyham.
Thank you. I'm John Mooneyham. I've been a workers' compensation attorney since 1989. I've been board certified in workers' compensation since 95. I've just been in this office for 2 months, and I'm really enjoying it, working hard to try to get it right.
Excellent. So I think what our viewers should get from that is that we've got diversity here in terms of jurisdiction. So we've got the northern part of the state, we've got the southeastern part of the state, we've got the southwestern part of the state, we've got mediator perspectives, a lot of lawyer perspective here in terms of past experience and good judges. So let's kick it right off and let's talk about the challenge of preparing for mediation. Judge Mooneyham, we have talked about this. What are the challenges of folks not being prepared for the mediation process?
Well, Judge Langham would speak from this from my prior standpoint as an attorney, because that's fairly recently ago, obviously. And I also neglect to say I also mediated workers' compensation cases for approximately 15 years prior to taking the bench. But several things that I saw both as an attorney and as a mediator are that number one, if you want to try to settle a case, you need to submit a demand at least a couple of weeks prior to the mediation. And the carrier's attorney needs to get with the carrier and try to get authority 2 weeks or so prior to the mediation as well. The demand should be in writing to the other side, and you need to confirm the demand in writing via email or letter to your client as well, where they're not surprised and where they have an agreement as what you want to demand. Prior to mediation, I think you need to look at whether any medical bills are unpaid and try to resolve those with the other side. You need to look at what liens exist. Is there a lien for Medicare or Medicaid conditional payments? Does VA possibly have a lien? TRICARE? Would Voc Rehab assert a lien? Is there a Medicare Advantage plan lien or a health insurance lien? You need to decide how you're going to try to resolve those liens, or I guess decide under 44022 if you want to not resolve some of those liens and just leave that out there. But that's certainly a dangerous game when you play that, leaving some liens open like that. Also, you need to look at whether Medicare set aside will be required. If it is, you need to get with the other side and talk about how you're going to deal with that. Few things that go without saying, but they're all seem to be a problem. You need to get updated medical notes. Make sure you have updated medical notes prior to the mediation, because nothing bogs down to mediation like trying to get medical notes or medical opinion from a provider. Also, if you need an updated payout ledger, you need to get that as well. Another thing that I think needs to be done is if there are past due attorney's fees, you need to try to resolve those prior to mediation. If you can't resolve those prior to mediation, you at least need to know what fee you're claiming, what the basis of it is, and the amount. You need to know the amount of cost you're claiming, where you don't have to get into an argument at the mediation as to whether a fee is due and how much is owed. Those are the main things just right off the cuff that I have that need to be done prior to mediation. And I think the two keys to mediation are just the basics, like in football, blocking and tackling. The coaches always say the game comes down to the basics. In mediation, I think the basics are preparation and communication. And if you don't do those basics well, the chance of settling at mediation or resolving issues at mediation is drastically decreased.
Ms. Carrier, do you have a position on this or any thoughts?
I do. I think another thing to consider, at least from the claimant's perspective, would be that it would be appreciated if the claimant's attorney would meet with his client prior to the mediation, discuss where the claim is at medically, find out if any of the pending petition issues have been resolved, if there's anything else that the claimant or injured worker is needing, if there's interest in settlement ahead of time, so that you can go ahead and provide that demand and not be at mediation and requiring an hour or 45 minutes to discuss all of these things and what the mediation process is, taking up the time of the mediator and thereby slowing down the process itself.
Judge Almeida, any thoughts?
I think the meeting with the client, whether you're a defense or a claimant, and the communication with the other side is key. You want to express to the other side where you're coming from, so if necessary, they can get the necessary authority or permission to resolve the issues. Unfortunately, as the state mediator, I saw many mediations where the first contact with a client was either in the reception room, or I've had them even be in the mediation room. Those mediations are not effective, and they defeat the purpose of resolving without the cost of litigation.
In that setting, Judge, when you were a mediator, did you tell the folks to go home and come back another day, or did you give them the impasse and let the process move forward? How do you react to that as a mediator?
Well, no, I did not impasse it. I tried to mediate. I tried to communicate directly with the client, the claimant. It was mostly on the claimant doing that, and the adjuster, to try to see where they could be a meeting of minds. Sometimes you don't have to have a general settlement, but if you can have a meeting of mind on one or two issues, you open the door for the rest to fall. And very important at any mediation, particularly in those, is if you open the door for the parties to think about a resolution, there may be an offer on the table which is not accepted because of lack of preparation. But once that offer sits down on the other party's mind, the claimant's mind, it gets a chance to ripen, and it leads to a resolution with a phone call between the attorneys.
And Judge Mooneyham, you said something that's piqued my curiosity. You said you should strive to resolve those outstanding attorney fee issues before mediation. What's the point in that? Why?
Well, I just think that a couple of points. Number one, it bogs down the mediation because you have to start talking about an issue that doesn't resolve the whole case. That's one issue. The other issue, it can put yourself in a conflict with your client as far as how to divide up the settlement proceeds, and that's never a good thing, I don't think. So those are the two main issues that come up. And another issue is I've seen mediations where the attorney for the claimant says that they're due a fee, and I go to the other side, and the other side, we don't owe them a fee. What do they owe a fee? What do we owe them a fee for? And you go around and talk to the claimant's attorney, and they don't know. They just say, well, I think we're owed a fee for this, that, and the other, but they can't point to it. And when that happens, the carrier's representatives get very upset, and understandably so, because they feel like they're being fleeced.
Or at least surprised.
Right.
I get that.
Right.
And one of the things that nobody mentioned that I'm curious about, and I'm going to throw to you, Ms. Carrier, nobody mentioned child support. And time and again, from my position, I hear about child support from injured workers, and it's after some deal has been made, either at or shortly after mediation, and then they're in contact with me about child support because, and I quote, nobody told me about this.
Right.
Is that an issue out there like the other liens that Judge Mooneyham is talking about?
It is an issue, and I try to go over that with the claimant and his counsel at the beginning, if there is interest in settlements. And I explain to them that if there's a possibility that you have any arrearages, you want to discuss what the impact of that's going to be with respect to your settlement. If they haven't heard that from their attorney, that allows them a chance to speak privately about it. I also make sure it's in my mediation agreement, and when I go over it with the claimant, it's reiterated again. But it's very often that you'll have communications between the two attorneys, and for whatever reason, it's not discussed with the claimant, and it comes up at the last minute, which is very problematic.
And starting on a sort of related topic, but a little different, Judge Almeida, we talked about the importance of an opening statement and using that sort of in the way that you're talking about meeting ahead of time instead of meeting at the mediation, but using it as a way to sort of lay out the foundation of what you hope to build in the mediation process. What kind of tips or ideas would you have for folks about what they need to do with their opening? Do they need to be long and involved? Do they need to be short and sweet? What's right?
Let me start by taking the flip side of the question before I address it. What is wrong is at the time of opening, be aggressive and abrasive and sometimes insulting on the other side, because that automatically shuts down completely any likelihood that there can be an amicable agreement. What is right is try to succinctly explain to the other side what you want and why you want it and why you're entitled to it. And the whys are very important. Not so much what you want, because that's in the petition and so on and so forth, but how you feel you're entitled to it, instead of just blanket showing that. And likewise in the defense, if you feel that something is not rightfully due, explain why succinctly. You don't have to tip your hand and give away all your aces, but lay it on the table, because remember, the other lawyer knows the law and knows how to get around it. But the important party of mediation is the claimant and perhaps the adjuster. And that claimant is hearing why he's not entitled to it, perhaps for the first time in the course of the claim. And that's going to assist a lot in persuading the claimant not to be an entrance, not to say, well, I want it or else. And particularly when the mediator speaks with him and tells him, look, you have the chance that the judge is going to deny this claim, because now the claimant is beginning to understand it, that it's just not an open and shut gift from workers' comp.
And Judge Mooneyham, I notice you're shaking your head in agreement. What would you have to add to that?
I had written down a statement I'd taken from an attorney that wrote an article on mediation. I neglected to write who it was, but I thought it was good for this purpose of this seminar. But this attorney said, in your opening, you need to be positive, confident, and upbeat. You need to try to persuade the other side to do something they're reluctant to do. You want to make it as easy as possible for the other side to eventually agree with you. And I thought those were good words of advice, and follow up on what Judge Almeida said. One thing I think you don't want to do is, even if you think the other side's case is terrible and they have no chance of prevailing, you don't want to say that, because obviously that'll shut down any chance of settling. But if you say that to the other side, if the other attorneys like me, I'll guarantee you they're going to work on that case every day to try to find a way to win that case. So you don't want to do that in opening. You want to be positive, confident, upbeat. I think that's excellent advice.
And Ms. Carrier, what are your thoughts?
Well, I obviously believe that mediation is a consensual process and should be maintained that way. I usually meet with each side privately. When we were doing things live, obviously I separated them in different rooms at the beginning, and then I would speak with them and figure out if a joint session was beneficial to the mediation. And in the telephonic process, I continue to do that. I have the parties call in, I speak with each side privately, and then I figure out whether or not having a joint session is going to actually help resolution of the case. I find that especially in these telephonic mediations, the professionalism on behalf of the attorneys is not as present as it would have been were they here live, and things that that would harm the mediation are more easily vocalized by attorneys, and it makes for a heated opening, and then it just ends up causing more trouble than it's worth. So I try to make sure that in speaking with the claimant and the adjuster in my opening, I explain that this is supposed to be a seamless process. Please listen to each other. Allow your attorneys to do all the talking. Sometimes that works, sometimes it doesn't. But to me, having an opening, which I've actually had attorneys tell me that they are entitled to an opening, and I explained to them, you are not entitled to an opening. The only opening that's required is my opening. And they may or may not like that, but that's what I think is the best process in order to have a fruitful joint session. I don't want the claimant crying at the end of the opening because of what defense counsel has said, or the adjuster being extremely upset because the claimant's attorney has insulted her or he personally because of how they've handled the claim. So that's how I handle it. That's the best way I've been able to figure it out through the couple of years that I've been here.
So you're avoiding either side inflaming the other.
Correct.
But one of the things that struck me in what you just said is that it's more difficult in a telephonic setting, and obviously with the COVID, we're doing that far more than we used to. Does that lead you to any thoughts about tips or suggestions you might have for folks in the telephonic setting, what they might do differently or might do more or less of that might be better facilitating success, which is what we really all want?
I think sticking to the facts and obviously not utilizing the fraud word or things like that in an opening statement. You can say that there's inconsistencies in facts that may bring about possible defenses. Things like that are fine, but utilizing fraud as a constant word throughout a defense opening, for example, doesn't help matters. In a claimant's perspective, accusing the adjuster of purposely mishandling the case and trying to hurt the claimant, or talking about things that are not relevant at all doesn't help. I just think that the attorneys need to stick to the facts, let me know what they want to accomplish, and then we can go ahead and discuss any heated issues separately in private.
And Judge Mooneyham, since we've gone off on that little bit of a tangent, any thoughts on telephonic mediation? Is it different? Would you have suggestions for folks on how to handle it differently?
No, I mean, I think it's different and it's not as effective to me. But again, I think the same rules apply about, preparation and communication. And it's not ideal, but we're not living in ideal times.
Yeah, it's true. Judge Almeida, any thoughts on the telephonic and how we can do it better?
My experience with telephonic mediations is limited to 8 years ago or 7.5 years ago when I was a mediator, and those rarely occurred where all the parties were on the phone. Back then, live was the common way, and perhaps the adjuster would be on the phone. I was concerned about the effectiveness of telephonic mediations in Dade County particularly. And after speaking with several of our mediators down here, I am surprised how successful they have been. And I think the lawyers are getting acclimated to the fact that this is the way of life. And a lot of the litigants on the claimant side particularly, since they know that they can't be exposed to a public scenario, they accept it.
Well, and in that regard, I would be remiss for not just being open and honest with the public on this broadcast. I have gotten just a landslide of compliments from various judges and mediators around the state regarding the manner in which they see professionalism just rising to the occasion during this COVID virus. They see lawyers, adjusters, doctors, all kinds of folks, nurse case managers, really going above and beyond to try to make things work. And I think that bears mentioning and really applauding. I think it's great that our community's coming together that way. Let me come back and start on a new topic. If we get through the mediation, obviously there's going to be a report whether we're successful or we're not. But if we're successful, Judge Almeida, the report is going to be the foundation for a resolution document of some kind, a settlement or a stipulation. Give us some thoughts on how we can do a good job with that mediation agreement in hopes that it's going to be an enforceable and effective tool.
That mediation agreement is a contract, and it can't be downplayed, and it's important. It's just as important as a contract when you purchase a home, and all of the terms and the agreements of the purchase are there. Unfortunately, because of many reasons, including the time constraints that particularly are seen in the state mediations, these contracts are oftentimes glossed over in its terms. And that's where I begin to see the problems as a judge, because one party disagrees with going forward with a mediation. Generally speaking, I would say almost 100% is the claimant. And then the judge is sitting there trying to decide whether or not there's an enforceable agreement, and all of the loopholes and all the inconsistencies and vaguenesses come forward, which essentially may lead to the conclusion that there was no true meeting of mind. If you want me to, I can give you some examples.
Yeah, I think that'd be handy. Go ahead.
Well, the first one that I have seen is a general release. And you ask yourself, what is a general release? Well, I think that logically we assume it means that the claimant, upon receipt of the money, is relinquishing all claims of all kinds whatsoever against the party paying the money. But here's where I've seen problems coming. Because if you have, say, employer A and carrier B, and they present a general release, you would expect it to be limited to A and B. But how many of you have seen a general release that includes employer A and all of its subsidiaries and all of its affiliates and everything? That wasn't covered. And is that general release binding or not? I don't know, because we as judges of compensation claims don't have any specific jurisdiction over the general release. The jurisdiction that we have is to determine whether or not it was an inherent necessity for the agreement, but not the language of the release. Also, I have seen grafted in the general release hold harmless agreements. Well, I think that the two of them are not the same, but I see it happen. So the general release it's a very delicate area, but yet it's commonly used. Other areas that I see where there's a vagueness in the matter is, and this I've seen come up many times, is contingent upon the employer's agreement, or if the employer is a governmental jurisdiction, contingent upon the employer's approval by the county commissioners, the city commissioners, or wherever it be. That's fine and dandy. But at what point in time does that contingency end? And the mediation agreement is then declared null. So I urge everybody who is facing that to put a time limit on it, 30, 60, 90 days, however the parties agree. So at the end of 90 days, the claimant particularly knows that there's no agreement and they can move forward. Within that contingency, there's also a problem. What happens to the medical benefits during this period of 30, 60, 90 days? that I've seen come up before me. And lastly, then we have the subject to CMS approval. And this one is very dangerous because the CMS approval, I don't know how long it's taking now. My experience has been that in some cases, I see years go by because keep requesting more and more information. What happens to the case during dependency of it? So these are the problems that we have on the agreement that leave this big hole open. And so to avoid having it come before me and having me make a decision which may not be amenable to either side, I think at the time of mediation, the parties should consider that and close that loophole.
Judge Mooneyham, I again see you shaking your head. Do you have some thoughts on this topic of drafting the mediation agreement?
No, I don't really have much else to add other than what Judge Almeida said. I think the attorney, and that's more so for the settlement documents, needs to be careful not to sign any type of hold harmless agreeing to indemnify something on behalf of the claimant, because that's not ethical for the attorney's ethics opinion against that. So other than that, I don't really have anything to add. I think Judge Almeida did an excellent job on that.
So you think there's an ethical challenge if the claimant is agreeing to indemnify, say, the employer carrier in the event that CMS or some other lien holder has a problem? You're putting the claimant in a pretty difficult spot.
Well, yes, but I don't think it's necessarily unethical for the claimant, but I think if the attorney agrees to indemnify some way the carrier for, I think that's a problem. That's what I was saying.
Okay, interesting pitfall. Ms. Carrier, any thoughts on this?
Yes, with respect to the general release, I would suggest, and I try to assist people to look towards doing this, is executing a voluntary resignation and agreement to execute a general release on a separate sheet of paper that has nothing to do with the workers' comp settlement. And that way they can include in that document, for example, ADA claims, any other claims that are possibly out there, and they can be specific about it, but it doesn't have to be incorporated in the workers' comp settlement and is addressed specifically between the employer and the claimant. With respect to the MSA approval contingencies, I find that the deadlines are great if you do put them in the mediation agreement, and also indicating that, of course, if the parties agree, that the claimant is entitled to palliative care until the MSA contingency has been reached. Those are just a couple of suggestions.
Well, without that palliative care, the thing that strikes me is the injured worker could be without just basic medications. Even if we're not talking about doctor's appointments, if your medication's cut off, it could be problematic. Let's turn and talk about the Judge Almeida mentioned the enforcement idea, and these things do tend to come up in front of judges, and someone is not wanting to go through with the agreement. I've actually seen that from the perspective of employers, not just claimants. Judge Mooneyham, have you seen that come up in your practice?
Well, truthfully, as a judge, I haven't had that happen yet. And in my time as an attorney, I only had a couple of clients that wanted to back out of a settlement, and the other side really didn't object too much, so we really didn't argue about it. And the only reason I only had a couple is because of communication. I always documented everything. When I made a demand, I sent them something in writing confirming the demand. And when I, accepted the final demand before I did, I always contacted them and told the client exactly what they were agreeing to and got their consent to all the terms of the agreement. So I haven't had a lot of experience with that, truthfully.
But that's because you're really pushing the information at that injured worker or at that company so that they're clear as a bell on exactly how it's going to come out if they agree to this, right?
Correct. I tell them that it's their case, not mine. When I was an attorney, I was just representing them in their case, but it was up to them to decide how they wanted to resolve the issues in their case. I could handle it procedurally. That was up to me, but substantively, what they were going to accept or not accept in settlement or resolution of the issues was up to them.
And Judge Almeida, I think you told us that that you have had some of these end up in your hearing room. What are the main pitfalls, and how do we stay out of them?
Well, we're in Dade County, the greater majority of our cases are non-English speaking individuals. And that's the first pitfall. And the first problem that I see and the very complaint that the claimants give is that they did not understand what was going on. They did not understand the terms of the settlement, or most important is that they never gave their attorney the authority to settle. The carrier has the duty of showing that the claimant's attorney had the explicit, clear authority from the client to settle for those terms. So then, coupled with the language barrier and some of the problems that we run in Dade County, we have the biggest problem is that because of the telephonic mediations, most of these agreements are signed by the claimant's attorney, not the claimant. So therefore, at the time of hearing, I've had this come where essentially there becomes a conflict of interest between the attorney and the client as to whether or not there was implicit agreement to settle for those terms. And the one thing that I caution the bar listening to this is that the rule requires that the telephonic mediations, the parties choosing to appear telephonically, furnish the mediator, I think it's 5 days before the mediation, the email address of the parties, presumably so the mediator can get everybody's signature. The most important signature, folks, is the claimant's. And without this email address, anybody out there is running the risk that that claimant could, for reason A, B, or C, decide that they're not going to go through with it. And you're going to have an enforcement problem when you have a document that is written in English on a non-English speaking person, signed by not that person. So it all depends. On a $5,000 case, you may not want to worry too much. But if you got a $100,000 case where it's big enough that you should spend the money and try to tighten the loopholes as best as you can, I urge you to do it.
Ms. Carrier, any thoughts on this?
Yes, I would suggest at least as a practice as a mediator to confirm the terms of the agreement with both sides before anything is written up verbally, obviously, because we're doing everything by telephone. And then I've actually added a sentence to my mediation agreement that indicates that the parties are appearing by phone. They have authorized their respective attorney to go ahead and sign the agreement on their behalf. With respect to the claimant, I also added a sentence that says the claimant has read or has been read to by their counsel this agreement, because a lot of the claimants are not able to print out the agreement or sign it. They don't have access to a computer, that kind of thing. So the only way to get a signature is through their counsel. So I've added a sentence that indicates that that mediation agreement has been read to the claimant by his counsel or obviously been provided to the claimant himself. And also that claimant has provided authorization. With respect to Spanish speaking clients, I usually go ahead and read the entire agreement to the client, to the claimant over the telephone. And I also indicate that there is a interpreter present, and that interpreter from that attorney's office will go ahead and sign the agreement as well, confirming that they have actually read that agreement to the claimant in their particular language, if it's not Spanish, Creole, or whatever it is.
And I don't remember the numbers anymore, but I recall about 5 years ago, we got a report from the state back when the Supreme Court was working on certifying translators, and it's over 100 different languages are spoken regularly in the state of Florida. And that was a big part of their challenge in finding translators, because it's difficult in every regard, but some of these languages and dialects are even more difficult than you might think in a general term. And we've kind of gotten off on this language challenge. I won't call it a barrier, but I think it's a challenge. To come right back to you, Ms. Carrier, what are our language as a primary language or language barriers? What's that doing to us?
I think that if you have the privilege of speaking another language, it's best to utilize it in your opening statement in order to engage the claimant and make them more comfortable. If their attorney speaks Spanish and the defense attorney speaks Spanish, I do the whole entire mediation in Spanish if it's possible. Obviously, I don't speak Creole or any other language, but if I did, that's what I would encourage as well. I recently had a mediation with a Bosnian speaking claimant, and the claimant's attorney was able to obtain a certified interpreter, and it all went smoothly, but it just takes a little bit longer. But I think if you can find and locate an interpreter that is closely related to that particular dialect of whatever language it is, that really does help the mediation process. But if you are able to, and it's possible to do it in their language throughout the entirety, that's also, I think, the best thing to do.
I perceive it as sort of a two-part analysis. Number one, it's perhaps easier for them to be in their primary language, but number two, and as important, it seems to me, it's a sort of a demonstration of respect for the person that you're willing to accommodate them in that way. Judge Almeida, you're also of a Hispanic background, and you speak Spanish far better than I ever will. But do you have thoughts on the language barrier issues?
I think the language barrier, if you can overcome it, is very important. There's two reasons for it. Obviously, as a mediator, we are communicators, and it's very difficult to communicate through an interpreter. But most important, trust. If the claimant doesn't trust the mediator, mentally they shut down what the mediator is saying and the explanation. And if the mediator, and in my case it was Spanish, when I communicated with them in Spanish, I always tried to figure where they were from. And if I had visited that particular country, I tried to bring out some commonality. Why? Because at this point, trust was establishing. We're like each other. We're not two different people. And the language is very, very important. Going to trust, I'll give you an example or something that happened to me that was quite funny. I had just come back from Budapest, and I had a screensaver picture of of the river, I think it's a Danube, with a castle in the back of Budapest. I had a mediation come in. The claimant sits down, the young lady sits down. I assume she spoke Spanish. I start the mediation opening in Spanish. They tell me, no, she speaks no Spanish, broken English only. She's from Hungary. And I noticed that she was staring at my computer intently. And I pointed and said, Budapest, my favorite, most beautiful city I've ever seen. She smiled, and suddenly she was not talking to her lawyer. She was talking to me about settlement. I was able to establish trust between each other. And that's what the mediator should achieve to do. Have that more than just verbal communication, but almost the spiritual communication with the individuals to develop that trust. Language is very, very important. And I think that a lot of people, and Ms. Carrier, you may understand this. Spanish, there's a lot of Spanish that are completely different spoken out there. And the Spanish people, some people, if they hear an accent from Argentina and they're from Mexico, that's like pouring gasoline on the fire. And so it's not just Spanish, but it's the different dialects that they have. the different way of thinking. So it's very, and I know I'm digressing from the outline, but it's very easy to lump all Hispanics in one box. And believe it or not, if you open that box, you're going to see hundreds of little boxes. And sometimes there's been wars fought between Bolivia and Ecuador over a football game. So gives you an example of how distinct we are.
And I respect and understand how that isn't a language issue, but I suspect that we find that Judge Mooneyham in a lot of different ways in disputes. I don't know if you've ever had anything like this come up, but I once had a case fail in mediation, and it basically came down to what Judge Almeida just said about football. It wasn't soccer, but I ended up with a gator and a bulldog in the same room together, and things just didn't go well. Have you had experiences like that where cultural or educational or background differences just cause problems that you as the mediator have to then try to overcome?
No, I haven't really. I do have a point on what Ms. Carey was saying, though. I think she was right on point. There's a Florida Supreme Court Mediator Ethics Advisory Committee opinion. It's opinion number 2017-002, dated December 13, 2017. That's opinion 2017-002. MEAC opinion dated 12/13/17 that says the mediator cannot be both the mediator and the interpreter, and the mediator should conduct a joint session in the language common to both parties and write the agreement in the language used in the joint session, but then it must be translated into English by someone other than the mediator. And that's exactly what Ms. Carey was saying there.
So it seems to me, though, that you may have issues because you may not be able to do it in a language that both parties share. It may very well be that
Right.
that the parties don't share English. Is that something you run into, Ms. Carrier?
I don't understand the question. I'm sorry.
Where you have one party comes in and their language is not just primarily Spanish, but maybe only Spanish. So they don't speak any English. So conducting the mediation in English is going to exclude them, or conducting it in Spanish may exclude the employer carrier who speaks only English. So how do you deal with what Judge Mooneyham just said when there is no commonality? There's not a single language that everybody's comfortable with. How do you work through that?
Well, if it's a Spanish language, for example, situation with the claimant, then I usually will go ahead and with the claimant in Spanish and have the interpreter interpret my Spanish to the attorney in English, if that makes any sense. And then, of course, with the other side, we would just speak in English. But that's usually how I do it, unless the attorneys are uncomfortable with that, and then I just do the whole entire thing in English through the interpreter.
I don't like generalities because, you know, we can assume a lot of things, but it sounds to me one generality that we might agree on, all of us, maybe, is that mediations where there's an interpreter involved are more complex and take more time than others. Is that fair?
Absolutely.
Yes.
Yeah. It seems to me like that might be something to talk about. Judge Mooneyham kind of led us off with communicating ahead of the mediation. Maybe that would be a good thing for everybody to share with each other before they ever get to the mediator's office, that there's liable to be these cultural or language issues and barriers that we're going to strive to deal with. Judge Almeida, I want to come back to you. You said something about contracts, the settlement agreement being a contract. Does it all have to be integrated? In other words, all of the terms have to be in the written agreement? Can the contract also include things that were said at the mediation? What are you going to look for as a judge in terms of deciding if there's a deal, and if so, what are the exact terms of the deal?
Well, answering what was said at the mediation, everything at the mediation is privileged and confidential unless the parties agree mutually to waive it. But if at the time of the mediation, they jointly agree to put this particular language that goes. There's no problem in that. The mediation agreement on its own can stand. If there's a mediation agreement where the claimant agrees to settle for $10,000, the statutory fee is paid, and let's say they leave it at that. Technically, once the motion for approval of attorney's fees and allocation of child support is filed, that's all the judge approves. The judge does not approve the underlying settlement, the releases, or whatever is signed. The parties, particularly nowadays, the insurance company choose to prepare long agreements that the other side signs. But on its own, a mediation agreement is sufficient to settle a case, not to get the fees approved or the allocation of child support. And this is what a lot of people don't comprehend, the validity of this document. Now, very important to consider in this particular document is that, and you were mentioning the agreement or disagreement. Well, that's a different topic that goes to mediation confidentiality. But I was doing some research as to what happens when the mediation agreement has a mistake, a mutual mistake. And if you want me to, I can address it now or later on, Judge.
Oh, go ahead and touch on it.
Well, this particular case is very interesting because it involved a contractual relationship for the acquisition of real estate. And there was a little mistake, only $600,000 in the terms of the agreement, which led to a lawsuit. And one side was trying to reform the contract, and the other side objected. And in the process of attempting reformation, it became necessary to call the mediator to testify. So the case, and I'm trying to get the citation for it. I got so many papers here. The problem that arose, I got it here, was twofold: the mediation confidentiality and whether the judge, the court, could reform a mistake in a mediation agreement. The case is DR Lakes versus Brandsmart, 819 Southern 2nd, 971, 2007. It's a 4th District Court case. And there the court held, number one, that given the circumstances of this case, the mediator could testify as to what occurred in the formation of the agreement, not the discussion of the agreement, but the writing of the agreement. And it went on to say, and it explains why it would go against judicial principles not to allow that. And it went on to say that given the circumstances of this disparity, I should say, the court had the power to reform the agreement, which it did. And now, mind you, we're dealing with a circuit court case, general jurisdiction. Comp's a little different because we have 440.25 that has the provision that the mediators cannot testify. How could that be affected on a situation such as the other one? I don't know. But on the case that I cited, 440.25 was not applicable.
Mm. And Ms. Carrier, I'm guessing, we've never spoken about this, but I'm just going to guess that being subpoenaed to testify as a witness about a mediation is probably amongst your favorite things as a mediator, huh?
Absolutely not. I've been asked, I believe, twice, and both times, the judge was like, "I'm so sorry, but no." It happens a lot. I don't know why people would want me to testify and why they don't understand that I can't. And they still ask, but it is what it is.
So do you perceive that lawyers or parties just don't understand the idea of confidentiality and the statutory prohibition Judge Almeida's mentioned, or is it just wishful thinking? They think they'll ask in hopes of a different outcome? What's driving it?
I'm not sure. I think that probably it is just that they don't know that they can't ask me to testify.
Hmm.
That's what I would think.
Judge Mooneyham, any thoughts on the confidentiality issue or the structural issue that Judge Almeida's raised?
I do, Your Honor, and certainly I agree with Judge Almeida. 44025 says that the mediator is not supposed to testify, or you're not supposed to reveal privileged confidential information in mediation without the written consent of all parties. But if you look at the mediation statute, which is Florida Statute 44.405, it says that the confidentiality can be waived. And if one of the parties is trying to void the settlement agreement, then another party can offer evidence for the limited purpose of establishing or refuting legally recognized grounds for voiding or reforming a settlement agreement reached during a mediation. And that party waives the privilege, but only to the extent necessary for the other party to respond to that disclosure or representation. Now, that's not a, that's a general mediation statute. There is a case as well, and it's not a workers' comp case. So there's an interesting interplay here. There's a conflict. McKinley versus McKinley, obviously it's a domestic dispute, 648 Southern 2nd 806, where the third DCA held that it was error not to allow the mediator to testify when the wife waived the statutory privilege of confidentiality. And there are a couple of JCC decisions that were just entered this month where mediators did testify in an enforcement agreement. So it does happen. I don't know whether it's proper or not, but you've got a conflict between the mediation statute 44.405 and 440.25 subparagraph 3.
Privilege seems like a challenging topic because, at least from my perspective, and I've only conducted a couple of mediations in my career, but Judge Almeida, what does it do to your credibility as a mediator if word gets out that you're willing to engage as a witness for one party or the other regarding the process? Is that going to hurt the confidentiality and the forthcoming nature of folks?
I think so. I think that particularly for state mediators, that confidentiality is very important. I've had this issue come up as a judge on 2 occasions, and one of them was a private mediator here in Dade County who got subpoenaed because of a dispute on the agreement. And after a long argument of counsel, I arrived at the Solomonic resolution of allowing the mediator to come in to testify as to his name, address, and the date of the mediation, and nothing else. They dropped the issue at that point in time. But also, realistically speaking, I don't know about you, Ms. Carrier, but when I was a mediator, they walked out the door and I started the next mediation. I forgot this mediation. And particularly 4 months later, you have no idea who they are. So that's a matter of practicality when you do 6, 7 mediations. But I think practicality is very, very important. And if you got to understand the underpinnings for that theory, the underpinning is to allow the people to speak freely their mind, voice their opinion, voice their feelings, voice their sentiments. If you start breaching that ability to do that, then not only the mediator will lose his credibility, but the entire system.
And believe it or not, we've been running for about 52, 53 minutes, and we need to be conscious of our time. So I think to close out, we'll start in opposite order and just give each of you a chance to give one thought in imparting as to what you would recommend for folks to do to be more effective mediators. Judge Mooneyham, let's start with you.
Well, to be a more effective mediator, I just think that listen to the parties and try to guide the case to a resolution. And I think just what everybody has said today is just a general rule. I think the mediator, I think the main for effect, I think the problem not necessarily with effectiveness of mediators. I think it's with sometimes with the participants. And again, I go back to the two main rules. That's to be prepared and be communicate and manage your client's expectations. I think it's a big thing. You don't need to tell your client they're going to get something they don't have any chance of getting. That would be what I would say, because I think we have excellent mediators. I don't think the problem's really with the mediators. I think it's more with the parties than it is with the mediators.
And I apologize. That's what I intended, was in the broadest context. So I appreciate you going that direction. Judge Almeida, any thoughts on the recommendation for effective mediation?
I think on behalf of the attorneys mediating, communicating with your client is very important. So they have an expectation as to what's going to happen. As a mediator, very important is try to achieve with the particular parties, and more so with the claimant, a level of communication that you understand each other and they have trust in you, because otherwise they're going to shut down to what you say. And that's my recommendation.
All right, great. And Ms. Carrier, last but not least, what's your parting thought on the topic?
And this is actually, as a state mediator, I find that reviewing the day ahead, going through the docket, familiarizing myself with the carrier's responses, the petitions, if there's pending motions for EMAs, really getting into the case beforehand and having those notes done so that I can start my next day having everything in order, I think is extremely helpful. And I think it helps not just me, but it also helps the parties, because I'm familiar with everything ahead of time. With respect to attorneys, I find claims attorneys and defense attorneys that send me a brief synopsis by email the day before or even an hour before of what they would like to get accomplished. I think that is really, really helpful, and I would encourage it.
And it has the added benefit of maybe assuring that they've looked at their file an hour beforehand.
Right.
I get it. Well, folks, we've run out of time. I want to thank the three of you. I think this is an excellent discussion that we've had today, and I think it'll be very helpful for both mediators and attorneys. And frankly, I think there's some injured workers and risk manager adjuster types out there that may benefit from watching this also, just to get some tips and some ideas on how to proceed. So thank you for being here and for participating. And for those of you watching, thanks for joining us. And if you have other ideas for what the OJCC could do in terms of providing on this platform the kind of training and education that will be beneficial to you, feel free to contact us by email and give us your suggestions. So thanks, everybody. Have a great day.
You too.